Good morning, ladies and gentlemen. Welcome, folks. Please remain seated. Folks, my name is Egan Walker. I have the privilege of serving in Department 7 of the 2nd Judicial District Court. I'm calling to order now cases PR 14-00025 and GR 14-00159, excuse me. The first case is, entitled the Hillygus Family Trust. The second case involves the guardianship over the person and estate of Susan Hillygus. Let the record reflect that for each of these matters, this session of court is taking place on January 12th, 2021 at 9 a.m. and is being held remotely because of the closure of the courthouse at 75 Court Street in Washoe County to in-person hearings due to the national and local emergency caused by COVID-19. The court and all of the participants are appearing through simultaneous audiovisual transmission means. I'm physically located in Washoe County, Nevada, which is the site of today's court session. The other court personnel who are present with me are Ms. Teresa Travers, the court clerk who's in Washoe County, Nevada. Ms. Mallory Nelson is the court case compliance specialist, also located in Washoe County, Nevada. And Ms. Stephanie Ketting is the court reporter who is located in Washoe County, Nevada. The record should reflect this session of court is open to viewing and listening through a simultaneous audio-visual link found at the washoecourts.us website. I'm going to call on each of the parties and counsel in a moment. As I call on each of you, please acknowledge that you've received notice this hearing is taking place pursuant to Nevada Supreme Court Rules Part 9 relating to simultaneous audio-visual transmissions in civil proceedings, and the 2nd Judicial District Court administrative orders and amended administrative orders beginning in a series first filed on March 20th, 2020. And finally, tell me if you have any objection to proceeding in this manner this morning. Let me go around the room. Let me begin first with Mr. Torvinen. Good morning, Mr. Torvinen.
Good morning, Your Honor. Todd Torvinen here on behalf of the guardian of the person who stated Susan Hillygus. That's Robin Renwick, who's seated to my left, and I indeed got notice of everything. In fact, I'm the one that generated all of the petitions and the pleadings that are the subject of this hearing this morning.
And do you have any objection to proceeding in this manner?
No objection, Your Honor. Sorry.
Thank you. Mr. Spitzer, good morning, sir.
Good morning, Your Honor. Thank you. David Spitzer from Washoe Legal Services is court-appointed attorney for Susan Hillygus in the guardianship matter. I received notice that we're proceeding in this format and have no objection.
Thank you. Ms. Christensen, good morning, ma'am.
Yes, thank you, Your Honor. Good morning.
Good morning. Are you appearing as counsel of record in this case for any party?
I am not appearing as counsel of record, Your Honor. I am appearing as an interested party that requested special notice in the guardianship. I am appearing from Douglas County this morning, Your Honor. I received notice of these proceedings moving forward remotely and have no objection. I do want to just briefly state, and perhaps we can circle back to this for a little more discussion after the substance of today's hearing is addressed. Circle back to the issue of pleadings in the trust matter reflecting notice upon me through the electronic system when the electronic system has not provided me that notice, Your Honor.
All right. Well, when and if issues of notice become relevant, then I'll expect you to raise an objection or an issue at that time.
Thank you.
We'll certainly circle back around to it. I have a person in the Zoom tiles labeled Roger. Is that Mr. Hillygus?
It is, Your Honor. I'm appearing from Dayton, and I'm having issues with my electrical and my internet. And I do object to the hearing proceeding as Zoom. I had been working with a criminal defense attorney, and I found out yesterday that she does not practice in the probate court. This was a surprise to my private investigator and all of the witnesses that were prepared to testify today. And I'm unfamiliar with how to proceed with Zoom, and I am looking for new counsel. And I would ask that we have a continuance to allow me to find new counsel to represent me in this matter. Thank you, Your Honor.
I hear the basis of your objection to be that you want a continuance. Is that correct, Mr. Hillygus?
I do need a continuance, Your Honor, to obtain counsel. I've decided that it's important that I have counsel in this matter to represent me. I had counsel, and I do have counsel for my criminal case, and it's prejudicial for this case to move forward until I have proper counsel to represent me. That's correct.
And if I understand correctly, you first investigated this issue with your criminal attorney yesterday.
I've retained my criminal attorney in November. We've been working together for months, and it was sprung on me yesterday that she only practices in jury trials. She only does criminal cases, and I have reached out to almost 24 attorneys yesterday. Ken Lyons, Wallace and Millsap, Kent Robinson, Dave McElhaney, Patricia Halstead, Doug Clark, Julia Gold, and I'm having issues getting appointments because of COVID. Some of the attorneys' spouses have passed because of COVID. I've been having to, I've had to quarantine myself. I've lost a recent family member of the end of the year on the 31st. And, you know, I need a continuance to get proper counsel to represent me because of the criminal case that's ongoing. And this would be prejudicial if this case were to go forward.
Well, Mr. Hillygus, you and I spoke last year on Zoom related to this issue of representation. And I'm distressed that you would have waited until the day before the hearing to first seek out counsel. If your representations to me are true, that you first sought alternative counsel yesterday, that was an unreasonable choice on your part. This hearing has been set for weeks, if not months. It is important now to resolve the remaining issues in your mother's guardianship and guardianship estate and the trust estate. And it would be unreasonable to wait until the day before the hearing to seek to substitute counsel in. You raised the issue of your belief about the prejudice of the civil case or cases, meaning these cases, and the criminal case against you going at the same time. And I gave you a specific opportunity in my written order last year to respond in writing to what legal basis you sought to interpose and how you believed civil cases were prejudicial to the criminal cases, et cetera. And nothing has been filed since the date of my order. So for those reasons, given your representations to me, I'll deny a request for a continuance because it's clearly designed at this juncture to delay the proceedings without good reason. Is there anything else you want to place into the record, Mr. Hillygus?
I've been working with a criminal lawyer since November. I'd contacted many lawyers in October after the last hearing, November, and I recently contacted yesterday after I found out that the attorney that I've been working with does not practice in the probate court. But I have contacted many other attorneys, and this is not for delay. I was just found this out yesterday. So the criminal defense lawyer does not practice in the civil court. She only practices in criminal. And so I'm also asking for reasonable accommodations because of my ADA because I'm disabled and I have an ADA representative, that for reasonable accommodations, I asked this court to provide me time to find proper counsel because Your Honor has already explained that I have mental disorder. So because Your Honor has claimed that I have a mental disorder and I do have a disability and I do have 2 TBIs, I asked this court to allow me time to find proper ADA or proper representation for this case.
Well, Mr. Hillygus, I have not made any findings against you or your mental health, just so the record is clear. There have been no hearings at which I would have come to a conclusion. Perhaps you're referring to comments by me or comments by my predecessor related to the illogical and unreasonable, candidly, litigation positions you've taken over the years in these cases. And the concern.
Hear anything? I'm having issues.
Mr. Hillygus,
I'm sorry, I cannot hear anything you're saying. I'm having issues with the internet. Your not coming through. I cannot hear anything that you're saying.
Mr. Hillygus, stop talking. I don't believe you when you say you can't hear me. We were communicating well until it appears I am making comments and or making rulings with which you disagree. Unfortunately, Mr. Hillygus, this is a pattern with you. What I'm referring to is when last we met, for example, you had filed a large tranche of information and paperwork with the court at the last minute, contrary to prior orders, contrary to reasonable practice. And I had indicated then that last minute machinations, filing of paperwork, motions, last minute motions, for example, your motion to continue this proceeding this morning, et cetera, that last minute machinations would be met with no success with the court. You have demonstrated a pattern over the years of at the last minute raising issues largely created out of whole cloth for the purpose of delaying proceedings. It appears that Mr. Hillygus has left the proceeding, or at least has terminated the connection. We have some choices to make, Mr. Torvinen. In my view, Mr. Hillygus, having been designated previously a vexatious litigant, having for many years demonstrated a pattern of disrespect for and an inclination not to follow court orders or court guidelines or court mandates, has this morning continued that pattern, seeking a tardy continuance, and perhaps, I don't know the truth of it, manufacturing electronic related issues. He claims this morning that his connection is unstable and he's unable to hear us or see us. Your thoughts about how we should proceed, Mr. Torvinen?
Your Honor, when you were speaking, what went through my head was that if you count the TPO that Mr. Hillygus filed against my client in December of 2013, we are now in our 8th year. Eighth year of this litigation. And as you well point out, this is a pattern of Mr. Hillygus. We are prepared to go forward. I, for one, am exhausted by this, speaking frankly to the court, and I want to be done. And I'm prepared to go forward, and so is my client. And so is Miss Lund, I might add.
Mr. Spitzer, your thoughts?
Thank you. In light of the circumstances today, I have no objection to going forward.
Well, Ms. Christensen, I don't mean to, I'm not sure you have the ability to weigh in, but I'll give you that opportunity only because we are in, to be sure, unusual times, and this is yet another unusual circumstance in this case. I don't know if any legal precedents, doctrines, or thoughts come to your mind. Ms. Christensen?
Thank you, Your Honor. I believe the court is well equipped to move forward and appreciate Mr. Spitzer's consent and Mr. Torvinen's consent, and would simply support the decision you make, Your Honor, to proceed if that's what you decide.
Well, I am concerned on many levels in these cases. If the allegations against Mr. Hillygus are true, related to the costs that he created in the trust case by his actions, and the costs he created in the guardianship cases, or the case involving guardianship over both the person and estate of his unfortunately deceased mother, his actions have been unconstitutional, unreasonable, perhaps unlawful. It is for the criminal courts to decide that, of course. And his actions could cost him potentially several $100,000 in retaxed costs. Mr. Hillygus has demonstrated himself to be intelligent in fact, highly intelligent. He has applied his intelligence to good effort at times. He has applied his intelligence in very nefarious ways at other times. He has demonstrated a clear understanding of the rules of process and the rules of procedure in these civil cases. He files in a timely manner when he chooses to, and he files in an untimely manner when he chooses to as well. I'm deeply concerned this morning that Mr. Hillygus is continuing a pattern of delay and obfuscation in these civil cases. However, I want to give Mr. Hillygus notice and an opportunity to be heard in this way. Mr. Torvinen, in your motion to retax costs in the trust case, you acknowledge that there is no legal authority in the chapter related to trusts to retax costs. Would you agree?
Yeah, it's limited. As you know, Your Honor, I filed the supplement to the petition in September, I think on September 7, 2020.
Thank you. Go ahead.
NRS 163115 sub 4 allows the retaxing of costs, but that's only limited to the removal, a petition to remove a trustee. Now, some of what Mr. Hillygus involved that actually to remove the judge multiple times. But that being said, there is substantial, as I pointed out in the petition, there's substantial common law out of the state of California, wherein a beneficiary acts unreasonably over a substantial period of time, should not profit from that, and that's under equitable. That's you sitting as a court of equity have the power to do that.
Well, in as much as I am a constitutional formalist and very reluctant to in any way be seen as creating law, I give you and Mr. Hillygus notice of the following. In the guardianship case, meaning in GR 14-00159, I take jurisdiction today over the assets in the trust case. That has never explicitly happened before in this case that I'm aware of. The cases have paralleled. They're, of course, in front of the same judge. But I specifically and explicitly today take jurisdiction in the guardianship case over all of the assets owned by the decedent, Susan Hillygus. Because, Mr. Torvinen, I give you and Mr. Hillygus notice of the following. NRS 159.345 in the guardianship case explicitly states as follows. If a guardian, number one, is guilty of gross impropriety in handling the property of the protected person, or two, makes a substantial misstatement in any report filed pursuant to statute or any account filed pursuant to statute, or three, willfully fails to file a report required by 159081 or an account required by 159.177, after receiving written notice from the court of the failure to file and a grace period of 2 months has elapsed, the court may impose a penalty in an amount not to exceed $5,000 and order restitution of any money misappropriated from the estate of a protected person, which must be paid by the guardian and must not be paid by the estate of the protected person. NRS 159.346, the very next section, provides that if a guardian violates any right of a protected person that is set forth in this chapter, a court may take any appropriate action, including, without limitation, issuing an order that certain actions be taken or discontinued, disallowing any fees payable to the guardian, after notice and a hearing, issuing an order compensating a protected person or the estate of a protected person for any injury, death, or loss of money or property caused by the actions of the guardian, or the failure of the guardian to take any appropriate action, etc. I give Mr. Hillygus notice today by this hearing. I intend to act on any allegations of defalcation by him in either the trust case or the guardianship case pursuant to the remedies in 159, and I'll record that in an order. Because Mr. Hillygus has not been given notice until this moment that the court would act pursuant to Chapter 159 and seek remedies, if appropriate, pursuant to these sections, I grant his motion for a continuance. I remain concerned that Mr. Hillygus is playing games this morning related to his connectivity, but I cannot, of course, say that. Many of us who've lived on Zoom for these 9 months have had connectivity issues. It is possible that Mr. Hillygus is having a connectivity issue this morning. I cannot rule that out. Because I intend to apply jurisdiction to protect the constitutional rights of his mother, now the decedent, in ways just articulated in this hearing, I grant his request for a continuance. He's entitled to notice and an opportunity to be heard. I cannot say that he is in fact unavailable this morning, although I believe he is, as I've said, manipulating the system. We'll need to reset this matter. Mr. Torvinen, do you have your calendar available to you to do that?
I do, Your Honor. I can bring it up.
All right. Mr. Torvinen, we were set for a day today. I don't know, I know you gave notice of witnesses and exhibits. Thank you very much for that. My review of those witnesses calls me to cause into question the need for an entire day. I don't mean to foreclose that. I'm just asking directly, do you think we really need a day to develop the evidence in this case?
Well, Your Honor, in a regular, ordinary case, even contested, it would be a half a day. But as we discussed previously, we set it for a full day in anticipation of unusual proceedings that tend to take a lot longer based on my experience, but it should take a half a day. I can't disagree with you about that. It's just set for twice that long because of the nature of this case.
Well, I beg your indulgence then, you and Mr. Spitzer, in this way. I've had the privilege of practicing with you gentlemen for these many years. You've had the misfortune of appearing in front of me as a judge now for over a decade. But I hope you'll agree, gentlemen, that I give to tasks the time necessary. What I mean by that is I might suggest we set this for a half a day, and I assure you both that if it needs more than a half a day, I'll give it more than a half a day. I think that might be a best use of all of our calendars, is my only thoughts about it.
No objection to that, Your Honor.
All right, Mr. Spitzer, any quarrel with that?
No, Your Honor.
So let's see, gentlemen, I invite the two of you to offer the first half day you may have available convenient to your calendars. I intend to set this as convenient to your calendars as I can, given my concern, given the late notice by Mr. Hillygus. I assume he did not reach out to either of you indicating he needed a continuance. Is that correct?
No, Your Honor, I did receive no communication regarding that issue.
Same for me, Your Honor.
All right. So given the late nature of his notice and either his technical difficulties or his decision to voluntarily absent himself from the proceedings to in effect control the proceedings by not participating, I intend to set this at your convenience. Do you have a suggestion, Mr. Torvinen?
Well, how about Wednesday, the 27th day of January? Anything there?
So as I look at my calendar, I have a very large asbestos case set for pretrial motions in the morning, and then my out of custody criminal docket in the afternoon. So unfortunately, that won't work.
The 28th?
The 28th is a pretrial motions hearing in a criminal case in the morning and Veterans Court in the afternoon.
Okay. I don't think the court's dark on the 29th, Friday.
No, I have my adult guardianship calendar Friday mornings.
I got Friday. I mean, it's a Friday afternoon. I'll do an afternoon.
Well, I prefer to do Friday afternoons, believe it or not, Mr. Torvinen, but I get in trouble with court administration because the court is technically closed in the afternoons on Friday.
Yeah, that's what I thought. Okay.
Your Honor, if I may, is there a day of the week that the court would have general more availability?
Yeah, I'll begin to look, and thank you for that. I do want it to be convenient to your calendars. An example I would offer, Mr. Torvinen, is that Tuesday, January 26th is open in the morning for me.
Okay, well, let me back up. I can do it. That's good. I mean, I do a radio show, but the radio show can come after this. This has priority, Your Honor.
Well, that's 2 weeks from now.
Correct.
If that is inadequate, I could also do February 9th in the morning. But
Let's do the 26th. If you got the time, Mr. Spitzer, see if he's available, obviously. But yeah, that I'll make it work.
Mr. Spitzer,
I'll make it work, Your Honor.
Ms. Christensen,
I'm very happy to accommodate your calendar and thank you for the time, Your Honor.
thank you. Ms. Lund, I have not acknowledged you yet this morning. I recognize you're a party and or a witness, but does that cause any difficulties for you?
No, it does not, Your Honor. Thank you.
All right. So we'll continue this based on the request of Mr. Hillygus and his non-appearance this morning to January 26th. Let me place a few matters into the record, however. I had indicated to all parties that they needed to identify any witnesses and any evidence they intended to use for this hearing prior to this hearing. Mr. Torvinen accommodated that request. Mr. Hillygus has filed nothing since the last hearing in this matter, despite the court's orders. He is not now able to supplement the record with a notice of witnesses or evidence. I want the record explicit. He has additional time if he desires to seek counsel. Certainly, he can do whatever he wants related to representation. But the continuance of this hearing does not continue the deadlines previously imposed by the court. A written order will issue today giving Mr. Hillygus and the parties notice of my intention to seek, if appropriate, to retax costs against Mr. Hillygus in the guardianship matter pursuant to Chapter 159, even costs that have accrued to the term of description, not term of art, estate of Miss Susan Hillygus. In the end, I have jurisdiction over her estate. Her estate, the guardianship estate, did not capture the trust assets appropriately, but the trust assets are no less her estate simply because they weren't gathered into the guardianship over her estate. There was no real necessity to do that. Having now taken jurisdiction over the trust assets explicitly in the guardianship case, all parties are on notice that any remedies by this court will be pursuant to 159345 and 159346. Further, Mr. Hillygus is ordered to make contact with court personnel, specifically Ms. Travers and or Ms. Nelson, the day before the hearing, no later than 5 p.m. So January 25th, no later than 5 p.m., Mr. Hillygus must make an electronic connection with court personnel, meaning Ms. Travers and Ms. Nelson or my designee, for the purpose of problem solving any connectivity issues. Today, for example, Mr. Hillygus could quite clearly hear me and was responsive to my questions for a period of time. I could quite clearly hear him. He indicated he could not make a video connection. I candidly don't believe him that he couldn't make a video connection, but we'll work through those connectivity issues with him the day before the hearing. Mr. Torvinen, if you want to use that time to perfect any of your own connectivity issues, you can. You're a very electronically savvy guy. I know you've not had any connectivity issues, but I offer you the ability to do that, or you, Ms. Christensen, or you, Mr. Spitzer, anybody who may want to make sure that they can have a connection in this case. Finally, I explicitly authorize our Nevada judges to record and broadcast the hearing on January 26th, consistent with their pre-hearing request in this matter. I had issued an order in this case authorizing a so-called press appearance or press participation in this case, and I continue that authorization for the hearing on January 26th. I note our Nevada judges checked in timely in this matter. I'm assuming that they're recording this feed and broadcasting it on YouTube, consistent as I understand it with what they've done in the criminal case. And so I continue their permission and authority consistent with my prior order. Are there any other procedural issues you think we should discuss, Mr. Torvinen?
No, Your Honor.
Mr. Spitzer?
No, thank you, Your Honor.
All right. Thank you, folks. Please look for my written order later today. I appreciate very much all your time. I'm sorry we couldn't use the time we had set aside today. The reasons we couldn't use that time will be determined, I suppose, upon another day. I look forward to seeing you. You're welcome. I look forward to seeing you all on January 26th. Staff, if you'll stay on the call with me, I would appreciate it.
Ms. Christensen?